One question that continues to come up for employers is whether working from home is a reasonable accommodation. The answer is yes, sometimes. I'm Alex Rubin of Rubin Employment Law. Under the Americans with Disabilities Act, or the ADA, an employer may have to provide a reasonable accommodation to a qualified employee with a disability, unless doing so would create an undue hardship for the business. The Equal Employment Opportunity Commission, or the EEOC, that's the federal agency that enforces the anti-discrimination laws, has made it clear that telework or working from home may, in some situations, be a reasonable accommodation. But that does not mean every work from home request has to be approved. Just to be clear, this video is for informational purposes only. It is not legal advice, and watching it does not create an attorney-client relationship. For legal guidance, please speak to an employment attorney in your state. The key question is whether the disabled employee can perform the essential functions of the job remotely. If physical presence in the workplace is truly essential, then the employer may not be required to allow the employee to work remotely. On the other hand, employers should be careful not to rely on assumptions or old habits. Just because a job was traditionally performed in the office does not automatically mean it must stay that way. This is where many employers get into trouble. Process is important here. When an employee raises a medical issue and asks for a change connected to that condition, the employer should engage in an interactive process. This means looking at the employee's limitations, reviewing the job duties, considering whether remote work would be effective, and exploring whether another accommodation might also work. It is also important to remember that the employer does not have to provide the employee's preferred accommodation if there is another effective option. A hybrid schedule, a modified workspace, adjusted hours, or another change may solve the problem without full-time remote work. Another issue that is often brought up is the pandemic. Many employees worked successfully from home for months or even years. The EEOC has said that temporary telework during COVID does not automatically turn every position into a permanently remote one. But prior successful remote performance may still be relevant evidence when an employer evaluates whether working from home is feasible. And employers should keep in mind that the ADA is not the only law that may require an accommodation. The Pregnant Workers Fairness Act may also come into play. This law may require covered employers to make reasonable accommodations for known limitations related to pregnancy, childbirth, or related medical conditions, unless doing so would create an undue hardship. Such local laws as the New Jersey Law Against Discrimination and the New York Human Rights Law also may require reasonable accommodations for pregnant or disabled employees. Here's what you need to know. Working from home may be a reasonable accommodation, but it is never automatic. Employers should avoid blanket denials and instead conduct an individualized, documented analysis. If your business is dealing with a remote work accommodation request, it's a good idea to get legal advice early. Call us at 973-787-8442. Email us at legaladmin@alexrubinlaw.com or visit us at alexrubinlaw.com/remote-work-accommodation.